Hi, good afternoon. Welcome to, I forgot what, Digital Transformation Thursdays. I know you just saw a video on Shorts. So Shorts is an event that we're organizing. If you're interested, it's the event page is on shorts.ph. So Shorts is a storytelling event. People can come up and tell their stories. You just saw the 8 rules of Shorts. Live without notes, and we're planning a webinar on August 20, and our theme will be locked down. And I'm going to play a video now for you, which is a promotional video for that event. So if you're interested in attending, or if you're interested in participating in lockdown, feel free to join us. And with respect to this video, before I start it, just as a word of warning. So you're seeing it. Please follow the warning. If you are photosensitive, or you have issues with respect to your vision, because there's going to be some flashes. There are going to be some flashes in this video. We advise you to look away. And then I'm gonna start the video now. Okay, so I just want to mention that so that's an event. If you're interested in participating in Shorts, just go to www.shorts.ph and participate. Send an email to entries@shorts.ph if you want to be involved in the next webinar or the first virtual Shorts. We've already done one event, and the archives are on shorts.ph. I urge you to go and visit and check those out. Okay, so welcome. I'm very excited about the topic today. We have we have a powerhouse panel of speakers, and actually I'm really quite surprised at the number of registrants that we've gotten this week, and that's why we've had to do this live on Facebook. So our topic today is resolving IT disputes through arbitration and ADR. And our speakers are two distinguished graduates from the University of the Philippines College of Law, Dr. Rebecca Khan and Janice Lee. So just to open up, the topic today, of course, is IT disputes. And I'm supposed to intro this topic by talking a little about IT contracts and IT disputes and why we think this is an important subject matter. So through the years, in our practice, we've advised at various stages of IT contracts, and typically it starts the role of the lawyer usually is at the beginning, and then never more. So normally, in the course of an IT project, if you're an IT manager, or if you're on the client side, or if you're on the supplier side, the first thing, one of the hurdles you need to get through once you have an agreement in principle is to have the lawyers review the contracts. And so this is a normal thing for the lawyers to come in and look at the contracts and sometimes have a meeting or two, negotiate certain things out, negotiate some certain certain contractual clauses in, and therefore move forward on that basis. And normally what happens, I guess in 99% of the time, the lawyers never see the contracts again, never hears about the issues that arose during the contract implementation. And normally, if you do hear from them again, that means that there's a problem. And the problem could be initially a potential dispute. And in some cases, it goes into a full-blown dispute where you do need to prepare for resolving the dispute either through the courts or through arbitration. Now, why did we focus on arbitration for this event? And the reason for that is because, number one, it's becoming a more common mode of resolving IT contracts. But the other thing that that we're seeing is that under the government procurement policy law, there is a requirement for government contracts that there be an arbitration clause. So, in fact, there have been arbitrations on government contracts that that have had problems. And as we saw about 2 or 3 weeks ago, and we had Arup Meiti talking about managing IT projects, the chances for failure are actually quite high when it comes to IT projects, especially in these complex IT projects where you're trying to marry hardware and software. They have to work together, and there are various service providers. I remember about 10, 15 years ago, there was a big project that we were trying to find some resolution, and there were problems. Various government agencies had decided to collaborate to build a common database. And what happened was they each brought their own budget into it. And in the course, they pushed through with it, but some of the, a lot of the hardware had been bought, so the PCs were bought, but the software was still in development, and then the other components couldn't be implemented. And so that project inevitably failed. No dispute arose from that. But today, we're seeing a lot of large-scale IT projects coming out there. PhilSys, or the National ID System, is one of them. EODB, Ease of Doing Business, are also, or through ARTA, are also having these large-scale IT projects. And we're going to see more and more of these. And so we're anticipating that there might be some disputes, and hopefully today's episode will help you navigate through them. Now, in my experience, what helps is, and any lawyer will tell you if you're in a dispute, what helps is having the evidence on the ready. And if you look at the contract, the way that it's written, and if you practice good project management principles, then you should be documenting every phase of your development, right? You should have weekly meetings, you keep your minutes, make sure that everything is documented, because it is this document, right, this record of the meetings and the progress of the project that will become the basis of the evidence that you will present in case it does come to a dispute resolution panel. But even before that, one of the most helpful things you can do is to, in the contract itself, or if it's not a contract, if it's a scope of work, you make it very, very clear what the deliverables are in a project. You say, okay, you have to deliver software that has these functionalities, and you itemize the functionalities. And if you can specify what the functionalities are, that it is supposed to do A, B, C, and D. Right, and you specify what those are. So when you do that, then it's very easy later to determine, was the deliverable sufficient? Because then either side can show whether A, B, and C are present, or maybe A is present but B and C are not present. And therefore, it's very easy to tell whether or not the deliverable had actually been completed. The other thing that you can do to make it very clear is the timelines that you're going to set. So in the contract should have very strict timelines, and you should specify when the deadlines are. And then ideally in these situations, when you set a deadline, normally there is a period for what they call acceptance. And that is when the customer receives the IT product or the service, and then they are able to check whether or not there are bugs, right, or unintended features. And then there's a correction period. So you can tell whether or not there's a delay. So these two things in the contract level are very simple rules that you can follow when drafting the contract to avoid problems later. But as I mentioned, it's also important to document the progress because in many of these types of disputes, it becomes a he said, she said type of problem. And you don't want a situation where the panel that will take the case will have to figure out who's telling the truth. But if you have very specific deliverables, very specific timelines, and it becomes simpler for the lawyer to prove who is at fault. Okay, so moving on to our first speaker, who will talk about the way we divided up this topic was we looked at the two major types of disputes, and the reason why we have a speaker from Singapore is because we are looking at first. We want to talk about domestic arbitration that where it's likely to happen in the Philippines, and then we want to look at arbitration that's likely to happen in Singapore. Now, the reason for the Philippine perspective, and we will discuss not only, of course, domestic arbitration, but international arbitration that will happen in the Philippines. We have Dr. Rebecca Khan, who specializes in international arbitration and litigation. Her experience includes arbitrations before the International Center for Settlement and Investment Disputes, ICSID, and the International Chamber of Commerce, as well as disputes before the World Trade Organization. Rebecca was part of the Philippine delegation to UNCITRAL during the drafting of the rules on transparency in treaty-based investor-state arbitration, and was appointed by the Philippine Supreme Court to participate in the drafting committee for the special rules of court on alternative dispute resolution. She teaches courses on international investment law and government contracts at the Masters of Law program of the UP College of Law. Her academic writing in the area of international arbitration has been published as book chapters in Europe and the United States and the Philippines. She holds a Doctor of Juridical Science, summa cum laude, from the Central European University in Budapest, Hungary. As a Fulbright scholar, she obtained her LLM in International and Comparative Law with highest honors from the George Washington University in Washington, D.C. And I'd like to welcome Rebecca. If she could, you need to turn on, there you go, and unmute. And I'm going to hand over to you, Rebecca. I will now share your slides. This is on me.
Thank you very much, and good afternoon, everybody.
Right, and here is your slides. Okay. Thank you, Rebecca.
Right, thanks for that introduction and for setting up the scene for us. So now that our members of the audience have become acquainted with what an IT dispute might involve, the particular nature of IT disputes, we're going to look at arbitration as a form of dispute settlement for these kinds of disputes. We're going first. I'll give you a brief overview of what arbitration is, and then we'll also discuss why it's especially attuned to resolving disputes in the IT field, why it's an appropriate dispute resolution procedure. So you've probably heard the term ADR in the past. That's shorthand for alternative dispute resolution, and arbitration is under this umbrella of dispute resolution procedures. I just want to bring to your attention that arbitration isn't the only form of ADR. There's also mediation and conciliation. However, the dispute resolution form that's often indicated in contracts is arbitration. Also, I want to bring to your attention that ADR is increasingly being called appropriate dispute resolution. It was called alternative dispute resolution in the past because it was seen as an alternative to court litigation. But now, since more and more contracts specify arbitration as a first resort, ADR and that general and that umbrella of dispute resolution procedures under it is the term nowadays it's appropriate dispute resolution. However, in our laws, particularly the 2004 ADR Act, Philippine law still uses the term alternative dispute resolution. So what is arbitration? Some of you may be familiar with it. Some of you might not have any idea. So I'll set up a definition for you. So arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. So there's lots of elements to that definition. We'll get down in a little bit. So it's a private dispute resolution procedure, and by private that means it's an alternative litigation in court. Courts are of course part of the judiciary, a branch of government. Arbitrations, while there are some government arbitral institutions, arbitrations are generally run by private institutions or convened on an ad hoc basis. That means not necessarily affiliated with a particular arbitral institution, but organized, and then private individuals are appointed to be arbitrators. Now, an important thing, since we're looking at, for the first part of this webinar, we're looking at government contracts in particular. I want to bring to your attention that the Government Procurement Reform Act, or Republic Act 9184, specifically requires arbitration as a dispute resolution procedure. So Section 59 of this law specifies that government contracts should include a dispute resolution clause that refers any disputes to arbitration. So I'm trying to go to my next slide. So now that you know what arbitration is, generally, let's look at some key features and advantages of arbitration. So you'll note from the definition that it's a dispute submitted by agreement of the parties, and this speaks to the core element of arbitration, which is consent. Arbitration is based on the consent of the parties. That means that they have agreed to submit the dispute to arbitration, and this can happen. This can happen in two ways. So we already mentioned that government contracts require an arbitration clause that refers any potential disputes. That means even before a dispute has arisen, at the point of the contract is being formed, being signed, parties have already agreed that if any dispute arises with respect to the contract, they are going to use arbitration as a dispute settlement procedure for that contract. That's agreeing to submit to arbitration before a dispute has even arisen. It's also possible in some contracts, so that's a requirement in government contracts. There are some contracts that, so for example, contracts between private parties where they did not provide for arbitration. But if when a dispute arises, they think that it's better to go to arbitration rather than a court, they can submit, they can at that point, after a dispute has already arisen, can agree to submit that dispute to arbitration. So that's called a submission agreement. So you have your arbitration clause as part of the contract, or a dispute resolution clause as part of the contract. That happens before a dispute even happens, even before the project is embarked. And then you have the potential to make a submission agreement. So this is a subsequent agreement between parties to submit the dispute to arbitration, just in case the contract did not contain an arbitration clause. Now, an arbitration clause in a contract, it is a contractual provision, so it is binding on the parties. So just like all contractual provisions which must be respected, an agreement in a dispute resolution clause in the contract to submit to an arbitration makes it mandatory for the parties to submit that to arbitration. If one party decides to go to court, the court will, under Philippine law, refer them to arbitration because an arbitration clause exists in that contract. Now, the second key feature is that parties can choose the people who will decide the dispute. The disputing parties can appoint arbitrators. They essentially choose who would be the best people to decide their dispute for them. Now, an arbitration can be decided by a sole arbitrator, meaning there's just one arbitrator, and that means the parties agree who that arbitrator will be, or if they're submitting the dispute to an arbitral institution, perhaps that institution has procedures for appointing that sole arbitrator. Typically, just as often, or perhaps slightly more often, a dispute will be decided by an arbitral tribunal composed of 3 members. And in that instance, the typical appointment procedure is that when a claim is submitted, the claimant already nominates an arbitrator, and then when the respondent responds to that claim for arbitration, they likewise nominate an arbitrator. So each party gets to choose who their arbitrator will be. And then, depending on the procedure they've agreed upon, or depending on the procedure of the arbitral institution to which they've submitted their dispute, the president of the tribunal will be decided either by the agreement of the parties or by agreement of the two appointed arbitrators, or by appointment of the arbitral institution itself. So so the procedures vary depending on the agreement of the parties and depending on the arbitral institution that's handling the dispute. And we will get to we will take a closer look at why it's ideal for parties to choose their arbitrators in just a bit. However, I do want to highlight at this point that just because parties can choose who their arbitrators will be, that doesn't mean that those arbitrators are advocating on their behalf. No, arbitrators must still be impartial. While they are not judges, they should still maintain that impartial nature of a judge in deciding the dispute. The parties just nominate them because they think that that is the appropriate person with appropriate expertise to decide their dispute. But that person is not an advocate. They are an independent decision maker on the dispute. Also, another key feature is that proceedings are confidential. You know that court procedures are, by their nature, public. And when it comes to IT contracts, there are certain aspects that parties will want to keep confidential: trade secrets, procedures, processes. Perhaps just maintaining standing in the business community, not letting everyone know that there's a dispute with one of their projects. There are many reasons that people will want to keep the proceedings confidential, and arbitration provides that option because while the proceedings are going on, it isn't publicized, not like a court procedure where, as a general rule, the public can enter a courtroom and observe the proceedings. In arbitrations, the hearings are parties can choose the venue. They can decide who the venue for hearings, decide who to allow into those hearings, and they have control about who has access to documents. Generally, arbitration is faster than court litigation, and that's one of the advantages that arbitration has over court litigation. IT disputes, by nature, information technology develops at a very fast pace and evolves so rapidly that if you're bogged down by a dispute, and then there will be, if there's a possibility for performance later on, the delay in resolving the dispute might affect the terms of the original IT contract to begin with. So when it comes to IT disputes, you want a rapid means of resolving the dispute, and arbitration offers a faster alternative to court litigation. Because when you convene an arbitral tribunal, the parties have considerable control over the calendar. They've essentially appointed people who are devoted to hearing their dispute, and depending on how busy those arbitrators are, things can move very fast and the dispute can be resolved fairly quickly. Also, arbitration provides a neutral forum for dispute resolution. When we think of government contracts in particular, there might be whether it's a fair or unfair perception that bringing it to court, which is a public institution itself, whether that gives the government an unfair advantage. This is, of course, courts are impartial and they should decide the dispute fairly, but it's that mere perception that bringing a government contract to a government institution for decision might give undue advantage to the government party in a government contract. So to avoid this unfair perception, arbitration offers that neutral forum for which to resolve the dispute, and parties feel more in control of this forum because they get to decide who will decide, and it's by electing their decision makers, the parties feel they have a fighting chance with respect to the dispute. Also, it is a binding procedure that results in a decision that can be enforced against the party. Now, the keyword here of binding, this differentiates it from other forms of ADR, such as mediation. Mediation essentially gets the parties to sit down and discuss their dispute, likewise with conciliation. And these procedures do not necessarily come out with a binding procedure. Arbitration, in contrast with these other forms of ADR, results in a binding procedure that results in a binding decision that can be enforced against the losing party. Also, with respect to enforcement, just like enforcing a court procedure, you're going to look at enforcing the arbitral award where it will be beneficial for the winning party, and that is where the losing party has assets. So arbitration, whether it's a domestic arbitration or an international arbitration, the arbitral awards that result from enforcement can be enforced in theory anywhere in the world. But if it's most likely, if you have clients dealing with projects in the Philippines, you're probably going to want to enforce in the Philippines if there are assets to enforce against. But the great thing about arbitration is the portability of the decisions rendered in arbitrations. We have a treaty, one of the most well-subscribed treaties in the world, called the New York Convention on the Recognition and Enforcement of Arbitral Awards. This treaty is from 1958, and most countries in the world are parties to this treaty. So it's one of those rare treaties that most countries in the world agree on. And the Philippines is a party to this treaty. And what this treaty does is, if you want to enforce your award in another country, which is also a party to the New York Convention, that treaty makes it easier to enforce, because courts will have very minimal interference with the content of the award and seeking to enforce it. So now let's look at the types of arbitration that we're going to briefly look at today. So you have domestic commercial arbitration and international commercial arbitration. So these would be based on contract. So earlier we were discussing arbitration clauses, and so when in commercial arbitration, whether domestic or international, resort to arbitration is usually done through the arbitration clause that we discussed earlier, or the submission clause, which we all discussed earlier. The key difference between domestic and international is defined by law. The key difference is either one, nationality of the parties, or two, the seat of the arbitration. The seat of the arbitration is where the parties have designated to be the place of arbitration. That doesn't necessarily mean that hearings will be held there. The seat of arbitration is important because it determines the law of the arbitration, or the lex arbitri, to be followed in the arbitration, which is different from the law of the contract itself. It could be the same law, might be different. So when choosing a seat of arbitration, if it's in a different country than if it's in a different country from where the parties are situated, that instantly makes it international. Under the definition, so the Arbitration Law of the Philippines, the 2004 ADR Act, incorporates by reference the UNCITRAL Model Law on International Commercial Arbitration. So UNCITRAL is a UN body that comes out with model statutes, and one of the model statutes that has come out with is the UNCITRAL Model on International Commercial Arbitration. It's referred to in an annex of the ADR Act of 2004. So this text from 1985 is incorporated by reference. There is a newer version of this UNCITRAL Model Law from 2006. However, what the Philippine law incorporates by reference is the 1985 version. And by reference to this law, which was adopted as an annex in whole, so this entire text forms part of Philippine law by reference. The definitions of international and commercial are provided in Article 1 here. So the definitions of what's international is, as I've already mentioned, if the seat is in a different place, from where the parties are, or if one of the parties, if the parties are from different countries. That doesn't mean, so you could, so note that you could have an international commercial arbitration in the Philippines if one of those elements are met. Domestic commercial arbitration means that the parties are from the same country, or in the case, so in the Philippines, they're both from the Philippines, their place of business in the Philippines, and then the arbitration is going to be conducted in the Philippines. I bring your attention again to the Section 59 of the Government Procurement Reform Act, which specifies that disputes shall be submitted to arbitration in the Philippines. So by definition, the law makes reference to Republic Act number 876, which is the Domestic Arbitration Act. But the law also, the arbitration law, the 2004 ADR Act defines international commercial arbitration in accordance with the Untitled Model Law. So there's a bit of a disjoint if you're considering a government contract, which requires arbitration in the Philippines, and if one of the parties is a foreign supplier, for example. So under the Untitled Model Law, that would be an international commercial arbitration, and that has some effect on the rules. So in 2009, the Supreme Court came out with rules on alternative dispute resolution. They have slightly different rules of how and when courts can assist with respect to these arbitrations. And I also want to bring into your consciousness investment treaty arbitration. So this is my specialization. Investment treaty arbitration involves, so this is, whereas the first two types of arbitration mentioned in this slide are contract-based. Investment treaty arbitration is based on treaty. So treaties are, of course, agreements between countries. So when you think of contracts as agreements between individuals or corporations, think of it, investment treaties are agreements between countries. Now, how does this impact potential dispute? Investment treaties incorporate a mechanism called investor-state dispute settlement, which allows a foreign investor to directly sue a state, which if that foreign investor's country has an investment treaty with the Philippines, for example, and their investment in the Philippines, if their project of an investment under that treaty, they could, and it was a government contract, then it might be possible for that foreign party to sue based on an investment treaty, to bring an arbitration based on a breach of a treaty rather than the breach of a contract. They could actually bring both. They are not mutually exclusive. I just want to bring into your consciousness that investment treaty arbitration exists. And it's particularly relevant if your client is a foreign company. So I could talk about investment treaty arbitration all day, but we don't have time for that. I just want to bring this concept into your consciousness. And I'm trying to go to the next slide. Okay. So now that we've looked at what arbitration is and what its key features are, let's examine why arbitrate IT disputes. So IT disputes arbitration is an ideal form of dispute resolution for IT disputes. I'd like to highlight these three reasons, which we briefly touched upon earlier when we were looking at key features. So first is the expertise of the decision makers. IT contracts, by their nature, are very technical in nature, requires familiarity with the kinds of processes or deliverables involved in these IT contracts, and not everyone has that expertise. And certainly, if you have a dispute in this area, you want the decision maker for your dispute to be able to understand what that IT contract involves, what the technology involves, or what is expected of the technology, what were the deliverables and was it met. So you want, because you're allowed to appoint your decision makers in arbitration, the expertise, you can choose arbitrators who have the necessary expertise to decide the dispute. And also, another advantage of having more, having decision makers who have sufficient or even expert knowledge in the field is that they can become more proactive when examining evidence. When an arbitrator is well acquainted with the type of technology involved or the types of deliverables in that IT contract, when an arbitrator is knowledgeable about a dispute, they can be more than merely passive listeners to evidence being presented. They can be proactive in asking questions about the evidence being presented or the testimony being presented. When your decision maker has expertise, it allows that decision maker to go beyond what's being presented by the party and ask the deeper questions. And this is definitely allowed in arbitration, not like perhaps it's more expected in arbitration, I would say, than in regular court procedures, where the judge will typically listen to the evidence presented, ask a question now and then. But when in an arbitration involving a highly technical dispute, you can have an active arbitral panel asking their own questions aside from the questions proposed by opposing counsel. And again, we've touched upon the confidentiality of the dispute resolution process. If the technology involved if the processes involved in the IT dispute are trade secrets, confidentiality is important for the client in these matters. So arbitration presents that a confidential forum to hear the dispute, which is different from the public nature of courts, as we've already discussed. And as we've discussed, IT disputes, so information technology by its nature, rapidly evolving, you want those resolutions, you want those disputes resolved quickly. So I'm trying to go to the next. So how does a dispute reach arbitration? You know what arbitration is, you know its advantages, you know its features. How do you even get there? So we've already mentioned the arbitration clause and in the contract itself, or the submission clause after the dispute has arisen. So contract-based arbitration, so you have that arbitration clause, or you have before the dispute even comes about, or you have the submission clause, and that is how you bring a dispute to commercial arbitration. Essentially, the party can invoke the arbitration clause and initiate a claim by submitting a request for arbitration and serving the other party with that request based on the arbitration clause. Or if they don't have an arbitration clause, they can agree to submit it to arbitration. That's how to initiate a contract-based arbitration. So for treaty-based arbitration, as I briefly just introduced you to a while ago, treaty-based, so instead of a contract, investment arbitration is initiated by filing a request for arbitration invoking the relevant clause or key breach, the breach in the treaty the clause in the treaty that's breached by the government party. So in treaty-based arbitration, when invoking the treaty, the government is always the respondent here, and the foreign investor is the one initiating the claim. In contract-based arbitration, it could be either of the parties. Any of the parties who feels like they're not, the terms of the contract are not being met, there's a breach of contract, they can initiate arbitration. So let's take a closer look at how contract-based arbitrations are initiated. And for that, we're going to look at arbitration clauses. So I'm going to my slide on arbitration clauses. So as I've mentioned earlier, the inclusion of arbitration clauses in the contract is mandated by Section 59 of the Government Procurement Reform Act. And here I've provided for you a sample arbitration clause. Let's take some time to read it together. This is a sample with the basic elements in there. So a sample arbitration clause might look like this. Any dispute, controversy, or claim arising under, out of, or relating to the contract and any subsequent amendments of this contract shall be referred to and finally determined by arbitration in accordance with, and then our parties can choose the arbitration rules that they want to use. In ad hoc arbitration, that is not linked to any specific arbitral institution, the usual choice is the UNCITRAL arbitration rule. Most arbitration institutions have their own rules, in which case parties can specify that. The arbitral tribunal shall consist of, and then parties can decide beforehand, do they want one arbitrator or do they want 3 arbitrators to decide their dispute? And then the place of arbitration shall be, and again, as I mentioned earlier, determining the place or seat of arbitration determines the law governing the arbitration, which has effects on enforcement and setting aside the arbitral award in the future. The language to be used in arbitral proceedings, if parties in different countries, they can choose to specify English or both their languages or another language. And the dispute, controversy, or claim shall be decided in accordance with the law of. So that's a substantive law. So you have the seat of arbitration, which determines the law of arbitration, and then you have the substantive law, which is the contract. So breaking down that sample arbitration clause, you have your basic elements. So we saw the basic elements reflected in that sample arbitration clause. You have the number of arbitrators and whether to choose 1 or 3. So it always has to be an odd number. You could even go up to 5, but that would be costly, time-consuming, and unnecessary. So typically, arbitral tribunals are composed of 1 arbitrator or 3 arbitrators. You want an odd number so that there's no tie. So in determining whether you want 1 or 3 arbitrators, parties should weigh the considerations of cost and efficiency against the value and complexity of the dispute. So the more, if it's a contract that costs a considerable number of millions of pesos and it's very complex, you'd probably want to go with 3 arbitrators rather than sole arbitrator. So depending on the complexity of the dispute and the cost of the dispute will determine your decision whether to go with 1 or 3 arbitrators. In the place of arbitration. So this determines the law that relates the procedural framework. So for example, the availability of interim measures of protection. So if the seat is in the Philippines, so courts can participate in a limited way in arbitral tribunals, and this is provided for in the 2009 Special Rules of Court Alternative Dispute Resolution. It also determines, the place of arbitration determines the nationality of the award, and that is relevant when it comes to enforcement. And however, regardless of the place of arbitration, parties may hold meetings or hearings anywhere in the world. So even if, for example, parties choose the seat of arbitration in Singapore, but it's more convenient for them to have their hearings in Makati, that is perfectly fine. And then you have the substantive law, which is the law under which the arbitral tribunal decides the dispute. Arbitration clauses can be expanded further if the parties wish. One of the great things about arbitration is the flexibility of the parties. So parties can actually design an arbitration clause that provides more than just the basics. So there could be an appointment procedure. So the typical procedure is each party gets to nominate an arbitrator, but then parties can also specify in advance how the president of the tribunal will be appointed. Will the parties agree to the president, or will the appointed arbitrators agree on the president, or will the arbitral institution decide president of the tribunal should be? Other Additional provisos in that dispute resolution clause might be the qualifications of the arbitrator. So this is something to consider if you are advising clients in an IT dispute. Depending on the complexity of your IT project, you might have some minimum qualifications for the arbitrators. Now, going back to the types of arbitration, of course, I just wanted to bring to your attention the types of arbitration that were relevant to IT disputes. So you have your commercial arbitration, whether international or domestic, or you have some treaty arbitration. Of course, there are other types of arbitration, and I'm sure you've heard of some of them, such as construction arbitration or labor arbitration. So not particularly relevant to our discussion today. I just want to bring your attention that there are many types of arbitration. And I just wanted to mention this, for example, qualifications of arbitrators. For example, in the Construction Industry Arbitration Commission, which deals with construction disputes, not all arbitrators there are lawyers, some are engineers, because some contracts might specify that one of the arbitrators has to be an engineer in order to be able to understand the construction dispute. And we can see how that would be relevant for IT disputes in particular. So is the IT project of such a complex nature that perhaps it would be useful that a software engineer is one of the arbitrators has to be a software engineer? Would that be helpful? Arbitrators are not necessarily lawyers. Most of the time they are, but arbitrators are not necessarily lawyers. It's really up to the parties to decide who is the appropriate person, what kind of expertise that person has inside the dispute. Parties can also specify in their contract dispute resolution clause the time period for the delivery of the final award, essentially giving time limits how long the dispute can run, and also provisions for appeal. Of course, in the Philippines, appeal is governed by law. There are certain there is some avenue for appeal with respect to arbitrations, even if it isn't binding. And so my last slide takes a closer look at treaty-based arbitration. So as I mentioned, this is another option that can be explored by a foreign or international supplier in an IT contract. It would depend, however, on their nature of activities in the Philippines. So to resort to investment treaty arbitration, the nature of activities of the foreign client does have to meet the standards of investment defined under that relevant treaty. Also, whether this is a possibility depends on whether the country of origin of the foreign supplier has an investment treaty with the Philippines. So again, treaties are agreements between countries. We're not talking about agreements between individuals or corporations here. Treaties are agreements between countries, and these particular types of investment treaties provides a mechanism by which a private party can sue a government directly. So in contrast with contract-based arbitration or commercial arbitration, a treaty-based arbitration does not rely on the dispute resolution clause of the contract. So the restrictions in the contract of where that dispute can be brought, those are not relevant if one is considering the avenue of treaty-based arbitration. This is an entirely different avenue that can be considered in the case of a foreign client that qualifies as a foreign investor. So that is your look at arbitration in general, types of arbitration, and how it's assumed as a dispute resolution measure for IT contracts, and in particular, the requirements under the Government Procurement Reform Act for requiring arbitration as a dispute resolution measure. So I hope you found that helpful. So Janice has some interesting points about arbitration in Singapore, and move on to her. Thanks for listening.
All right, thank you, Rebecca. So moving on to our next speaker, and just to what's the word? Set up the structure of the discussion moving forward. The reason why we thought it was important to bring in Janice, who will talk about the Singapore perspective, is that a lot of the providers, IT providers, the large IT vendors, typically have their headquarters in Singapore. So normally, when these large IT providers contract with a Philippine customer, if there is an arbitration clause, it's most likely to be seated in Singapore, and perhaps Singapore law will apply. So we feel that there's an opportunity here to bring in that perspective, and that's where JANICE comes in. So JANICE Lee is a foreign counsel for international arbitration at Harry Elias Partnership in Singapore. She's a graduate of the UP College of Law in 2008 and is a graduate of the Shaman Academy of International Law in 2011. She also holds an LLM, a Master's of Law in Public International Law, from Queen Mary University of London. She's a multi-qualified international arbitration counsel with qualifications in Philippines, England, and Wales, and New York, and has represented clients in cross-border disputes involving M&A, construction, energy, and commercial contracts. She's a panel arbitrator at the Beihai Asia International Arbitration Center and the Thailand Arbitration Center. And she also previously worked with the Singapore Arbitration Center. So welcome, Janice.
Okay, hello, thank you very much. I think what JJ failed to mention is that I was also a student in negotiable instruments back in the day. So it's a bit weird calling him JJ and not Sir JJ anymore. I will now screen share my slides, which I hope is visible.
Yeah,
and so thanks very much for that introduction, and thank you to Rebecca for providing such an excellent overview, and not even overview, but an excellent description of what international arbitration is, the procedures for it. So to the extent that some of my presentation materials have already been dealt with, I'll try to move past that. Basically what I'll do is, JJ was correct when saying that a lot of IT contracts involve Singapore merely because either foreign companies prefer Singapore as a seat, or they would like SIAC or SIAC arbitration. And we do see in my line of work, and even previously when I was at SIAC, we do see so many parties coming from, let's say one party is from Vietnam, another party is from the Philippines, and yet they choose to have their arbitrations conducted in Singapore because of a number of factors, which I will go into. So my job today is just to describe to you what arbitration would be like if you're doing it in Singapore. I will start with a few basics in Singapore arbitration. And because a lot of these contracts also prescribe SIAC or SIAC arbitration, to the extent that the SIAC rules or the SIAC procedures are applicable, then I will also go into that in more detail. Okay. So first we have, why is Singapore arbitration so attractive or appealing to a number of parties, and not just in Asia, but we get a lot of SIAC arbitration from parties in the US, from Europe, from Africa. We do get that a lot. And I've listed in the slide a number of reasons for this. So first, Singapore does have that reputation for independence. It has a perception of low corruption level. Language fluency is great. Everybody speaks English. And so a lot of foreign parties feel comfortable with that, and there's very good connectivity. The Singapore International Arbitration Act, which is basically the Arbitration Act which governs all international arbitrations, is also based on the ancestral model law, similar to the Philippines. It's a party to the New York Convention, which, as Rebecca discussed earlier, means that the award issued there can be enforced in over 150 countries in all the signatory parties to the New York Convention. There's a strong tradition of the rule of law. So a lot of parties feel very, very confident that whether it's a case before the court, or they have an arbitration but there are court-related proceedings, or in general, they have a very strong confidence in the rule of law, and that whatever procedures or regulations are prescribed will actually be followed. There's also a highly skilled judiciary, or they advertise we have a highly skilled judiciary, and more importantly, they have a very good non-interventionist approach with judicial support for arbitration. What this means is, for example, the courts are very much supportive of when two parties to a contract have an arbitration agreement. So for example, party A has a contract with party B, there's an arbitration agreement, party B decides, you know what, I don't care, I'm going to file with the court will take a look at the contract, and if they see that there's actually an arbitration agreement, more likely than not, the court will stay those proceedings. In other words, they'll suspend those proceedings and tell the parties, no, you have to go to arbitration. That's the general rule. Parties have freedom of choice of counsel. What this means is that you can actually choose anybody to be your counsel, and to be frank, you don't actually need lawyers to be a party to an arbitration. It's just that in these days, a lot of arbitrations are very, very complex. So most people, most companies feel more comfortable hiring outside counsel. That being said, one of the questions that we usually get is, do you have to be Singaporean or Singapore qualified to be an arbitration counsel in Singapore? And the answer is no. For example, I'm not Singapore qualified, but someone like me, qualified in the Philippines, others, is allowed to practice arbitration in Singapore. The government has made sure of that they allow foreign practitioners to come into Singapore and practice international arbitration. And that ties into the next bullet point, which says non-residents do not require work permits to carry out arbitration services in Singapore. So usually when you're working in Singapore or any other country, you would be required to get an employment pass or a work permit, but for arbitration, there's a specific exception to that. And this is also in line with the Singapore government's push to have Singapore as a hub of international arbitration in Asia. And there are a lot of facilities that support the conduct of arbitration. For example, one of the government-funded projects quite a while back was the development and building of MAXWELL chambers. MAXWELL chambers is actually a hearing center. It's an integrated facility for hearings where all of your, they have dedicated rooms just for hearings. You don't have to set it up. They're extremely well qualified to conduct your hearing. So essentially you just book a room and they'll take care of the rest for you. And lastly, third-party funding is allowed in the field of international arbitration and other related proceedings. So for those who may not be very familiar, third-party funding is a situation where you have a claimant in an arbitration. They want to file a claim, but perhaps they don't have enough finances, or they're not liquid enough to fund the entire process of arbitration. What they do is that they can look to what is called a third-party funder, and third-party funders are essentially investors who look at potential disputes or potential claims, and then they will fund they will fund your filing of the case, hiring of lawyers, and then of course there's a separate third-party funding contract for this, where they do get some sort of income at the end, either a certain percentage of the award or a certain percentage of any settlement proceedings. But the point to note here is that third-party funding, which is something that is not allowed in many countries, especially common law countries, is allowed or has recently been allowed in Singapore because, again, Singapore wanted to encourage international arbitration. So the next slide is essentially a photo of MAXWELL chambers, which I was mentioning before. On the right is a sample of one of their rooms for large arbitrations. So again, for those who are not very familiar or who haven't attended an arbitration hearing before, this is typically what an arbitration hearing would look like. You have at the left side of the photo 3-member arbitral tribunals sitting together. Maybe on one side of the long table are the claimants, counsels. On the left, on the other side are the respondents, their lawyers. Usually the witnesses sit at the little table in the middle, and that's also either you have fact witnesses or you have expert witnesses. Now I'm just going to do a side discussion on SIAC and SICC. And the reason I'm doing this is because I know that sometimes there are many clients who've had a little bit of confusion as to what the differences between these two acronyms are. So SIAC is a Singapore International Arbitration Center. It's an independent arbitration center that I mentioned before. It's the only local arbitration center in Singapore. They administer arbitration cases, sometimes also ad hoc cases. They don't administer it, but they take it in whenever the parties need somebody to appoint the arbitrator. And in order to have your case administered by the SIAC, your arbitration clause, which Rebecca discussed earlier, must actually specifically refer to an arbitration to be conducted by the SIAC under the SICC rules. On the other hand, if you look at the right side of your screen, we are talking about SICC. This is actually the Singapore International Commercial Courts. Now, it's not an arbitration center. It was created only in 2015. What it is it's a separate branch of the Singapore court judicial system, and it's designed specifically to deal with transnational commercial disputes. So your case can be heard by the SICC if it falls under, and if it complies with these three categories. So, for example, the claim must be of an international and commercial nature. They must have submitted to the SICC's jurisdiction, and they don't seek any relief in the form of a prerogative order. Oftentimes, sometimes when you file a case in court, when the court looks at it and understands that it is an international commercial dispute, they can actually also refer it to the SICC. And why did they have to create this special body? The reason is that they wanted a body within the judicial system which can deal with commercial cross-border disputes and still have some of the advantages that arbitration has. So I think as mentioned by Rebecca earlier, under arbitration, you have the procedure, confidentiality, flexible procedures. So for SICC, they also have confidentiality provisions which the parties can avail of. So they're trying to have a hybrid form between a court system where everything is public records, and then arbitration where everything is confidential. So, but the beauty of it, because what they're trying to do is that when you have a court case and then you do get a decision, then you get you have that in public record that you have a decision against you, as opposed to arbitration, where generally, as I mentioned, it's confidential in nature. So that's the main differences between the SIAC and the SICC. When you have an arbitration, and it says SIAC, it will go to the left side of your screen, to the arbitration center. Now, before I move on further to the rest of my slides, and I'm just going to show you an overview of the common stages in an international arbitration. And this is more for those who may not be very familiar yet with the stages or what exactly happens in an international arbitration. How is it different from court procedures? And I know Rebecca already touched on this earlier. So what I will do in this slide is to discuss these stages in relation specifically to the SIAC procedures. So first you have the commencement of the case, right? When you have a dispute you want to file against somebody else, what you do is you file a notice of arbitration. Most of this, the details of this will be in the SIAC rules, and again, I'll go into these a little bit later. Then you have the appointment of the tribunal, the person who is supposed to decide your case. Again, as Rebecca mentioned, they don't have to be lawyers. They don't have to be any particular nationality. Frankly, they can be anyone. But if you have a dispute and you have an IT dispute, you want somebody knowledgeable about your subject matter. I have seen many cases where parties decide to select an arbitrator because he's very famous or he's very well-renowned and well-respected in the community. But if you have a very technical dispute and your arbitrator doesn't really know that much about it, you will spend a long time or a significant amount of time in your hearing, in your pleadings, trying to educate essentially the arbitrator. So most of the time, you want the arbitrator to be quite knowledgeable already. After the appointment of the tribunal, most of the time the tribunal will set a timetable for the rest of the proceedings. And this timetable will include the submission of pleadings, how many pleadings, how long in between, do you allow amendments, is there a discovery phase? And then sometimes when the situation calls for it, you have submissions of expert reports. This is not common for all cases, but I would gather that for most IT disputes, it's if the dispute is of a very, very technical matter, you require specialist knowledge. Most of the time, parties want to submit expert reports so as to, as part of their evidence in supporting their claims. After that, you have the evidentiary hearing. Just like submission of expert reports, hearings are actually optional. Sometimes, if the dispute is very small, and then the issues are actually very simple, you don't need an evidentiary hearing. You can ask, if both parties agree, they can say to the tribunal, hey, why don't you just decide this dispute based on all the documents before you? So that's usually called the documents only arbitration. And that happens quite often for very small disputes. Lastly, after you have a hearing, sometimes you have post-closing submissions, which is pleadings based on everything that has transpired, including the hearing. And then you have the award. Once you get the award, then that, it's not the end of your dispute. You still have to enforce it, unless the other side decides, I'll just pay this voluntarily. So, like I said, I'll just go down a little bit to the nitty-gritty. So once you have a dispute, you've chosen SIAC arbitration, and then you decide, okay, I want to commence my arbitration. I do want to file against the other party. What you have to remember is you have to file the notice of arbitration, you have to pay the filing fees, and then you have to already start thinking about, who do I want as my tribunal members? Notice of arbitration isn't very complicated. If you look at the SIAC rules, there are certain things that it must contain. For example, the names of the parties, the nature of the dispute, but it doesn't require you to provide a full-blown statement of the claim, although you can choose to do so. It's not required. Payment, if I recall correctly, the current payment filing fee for the SIAC arbitration is 2,000 Singapore dollars. And usually you have to file this together with your notice of arbitration, or else your notice or your case is not deemed commenced. And the date of commencement is usually very important because a lot of timelines are pegged to that date of commencement. So as I mentioned, when you commence a case, you have to file a notice. And in the third bullet point, you will see some of the requirements that the notice of arbitration must contain. Again, it's very simple. You can actually compile this together if you're, let's say, you have a deadline wherein you need to file, you have a statute of limitations issue, and you need to file by a certain date. These are actually quite easy to comply with. So you need to demand the dispute be referred to arbitration. You have the contact details of the parties, a statement of the arbitration agreement, a description of the dispute, a nomination of the arbitrator, comments on other procedural matters. For example, what is the language of the arbitration? Is it in English? And as I mentioned, the applicable filing fee. So as to timing, when should you start filing your notice of arbitration? And so there's really no specific timing under the SIAC rules, but as I mentioned, you have to be aware of any timings under your contract. So for example, there are some contracts which contain very, very extensive reps and warranties. And sometimes I've seen contracts and I've had disputes where the warranties are under a time limitation. For example, your contract can say, okay, this is a warranty of ABC, and then in a separate annex, it will say something like, all warranties must be claimed within 2 years as of the closing date. So you have to be aware of that. So let's say you're in your last month before 2 years expires, then you really have to make the decision, do you file or not? Because otherwise your right to file an arbitration case could expire under your contract. In terms of content, like I said, it does not require very extensive submissions. And if you recall, I mentioned in the last slide that you have to nominate your arbitrator. If you don't, that's fine. Well, it is preferable that you do, but under the SEAC rules, if the parties do not nominate an arbitrator, the SEAC will nominate one for you. And in order to do this, what they will take into account is the content of your dispute, which is why the description of your dispute is important. They must understand, for example, okay, this is an IT dispute relating to maybe intellectual property, so that they'll be able to get somebody who is knowledgeable in that field, who has had experience maybe in IP or IT, and they will also take into account the quantum of the claim. So the quantum of the claim, meaning how much are you claiming for? I said, $2.5 million. And you don't have to quantify it at the beginning, although it's better if you do, but eventually you will have to quantify it at a certain point. One of the features of SEAC arbitration is that it has the possibility for consolidation of consolidation of arbitrations. So if, for example, you have multiple contracts all related to each other, it has provisions where you can file one arbitration in respect of several different contracts, as long as you comply with the requirements under the SEAC rules. This slide is about the selection of arbitrators. And I think, as Rebecca touched on, it is a very, very important aspect, because this is really what sometimes can make or break the case, because this is the person who will decide the dispute. They will decide who is entitled to what in terms of claims and defenses. So you do want somebody knowledgeable, at the very least, of arbitration, of the subject matter. So first, for example, you have to check the agreed procedure. In some more complex contracts, it already provides for a procedure to select the arbitrators. For example, we have seen certain contracts which state all disputes must go into arbitration. There must be 3 arbitrators, and no arbitrator can be of the same nationality as any of the parties. So you have to bear that in mind. Under SEAC rules, there's an expedited procedure available wherein the arbitration is compressed to 6 months. In that situation, even if your contract provides for 3 arbitrators, you can only have 1 arbitrator. So that's why I said here, you have to note this particular rule. Second, you have to check on your arbitrator's independence and impartiality. This is extremely important because, as Rebecca said, your arbitrator is not your lawyer. He or she or they are not your advocate. It's not their job to fight for you. Instead, they actually have to be very independent and impartial. Then, of course, you check their background, qualifications, seniority, experience, and familiarity with the industry. And language abilities is also often important. Familiarity with the jurisdiction, and availability. A lot of very senior arbitrators, you actually have a very difficult time pinning down their schedule. So you may get them as an arbitrator, but your timetable, which I mentioned earlier, can stretch to quite a long time if they are jam-packed with hearings, which means your own hearing may take 1 year, 2 years after. And the usual timeline of a medium-sized arbitration is about 1.2 years. So if you have your arbitration hearing beyond that, then it necessarily extends your timeline as well. And rates. In arbitration, because it's a private procedure, you do pay your arbitrator's fees. most of the time, the more senior arbitrator is, the more expensive they are by the hour, and you do have to pay them by the hour. If you have a SEAC arbitration, it's different because they calculate arbitrators' fees on an ad valorem basis, which means they look at the quantum of your claim. As I mentioned earlier, at some point you have to quantify your claim, and then they apply a formula wherein they can calculate the amount of arbitrators' fees. Of course, this does not prevent the parties from agreeing that we want to pay the arbitrator on an hourly rate. Maybe for them it's more economical, maybe for them it makes more sense. I've seen arbitrations where the arbitrator himself requested for him to be paid on hourly rates, and if the parties agree, then that is what will happen. So again, choosing your tribunal, this is a reiteration of what I've said earlier. For procedures, so if you recall the chart earlier, after you choose the arbitrator, most of the time he will then set out a schedule of the proceedings or a timetable. And you have generally, you have the statement of claim, you have the statement of defense. Most parties will want another round of submissions, maybe a statement of reply, a statement of rejoinder. And the timetable for this is determined by the tribunal, or it can also be agreed upon by the parties. You also have the pleadings versus memorial approach. And there are two very different approaches in terms of making submissions. On the pleading side, you have written submissions, meaning I have my statement of claim here. Later on in the proceeding, I will submit my factual witness statements. At a certain time in the proceeding, maybe I will submit my expert reports. In the memorial approach, it's more common in common law countries. Everything is submitted all together. So you have your pleading, which is, let's say, your statement of claim. You already attach all the factual witnesses that you have, or factual witness statements, affidavits, and then you also attach, if you're using them, all your expert reports, basically all at the same time. And then same goes with the other side. They submit their statement of defense. They attach everything that they have in support of that statement of defense. So how this is done is, again, because of party autonomy, the parties can agree which kind they want. Most of the time, if the parties cannot agree, the tribunal will make a decision as to which one will be followed. So I'm going now into the next icon, which is the conduct of the hearing. As I mentioned, you don't necessarily have to have a hearing. In some disputes, smaller disputes, the parties decide that we can just go on documents only hearing. And this is usually for simpler issues. And it really saves a lot of costs for the parties, because you don't need to conduct maybe 3, 4, or 5 day hearings, paying for your lawyers, your arbitrators, and your experts' time. So if you're confident that a lot of your issues can be decided just based on the pleadings already, then it is something that you can also opt for. So on the other hand, if you do decide to conduct a hearing, there are certain things that you have to bear in mind. So first, you have the list of issues. You want to narrow down as much as possible what kind of issues will be talked about during the hearing, so that you don't stray, you don't waste anybody's time, because again, you're paying everybody for their time during the hearing. You have a hearing timetable and allocation. So for example, I am the counsel for the claimant, and then somebody is the counsel for the respondent. We already agreed I will have maybe 40 minutes for my opening statement. The other side has equally 40 minutes. We can agree that I have half a day to cross-examine their witness. They can have half a day to cross-examine my witness. So all of these can be agreed upon before the hearing even begins, so that it's very, very efficient. You can also agree on the order of witnesses, and I can decide, I feel that strategically, witness A is better to, he's my strongest witness, I want to put him up first, or whatever reason. You may have different strategic reasons for presenting your witnesses in a certain way. And then, of course, as I mentioned, you do have cross and redirect examination. You can present additional evidence. Sequestration of witnesses usually occurs when you have multiple witnesses and you don't want witnesses number 2 and 3 to hear what number 1 is saying until after, you don't want them inside the room essentially until after their turn being cross-examined is over. So again, usually the parties would agree on this rule, and it's a very common thing to have in large arbitrations as well. Attendance of party representatives is important because again, everything can be agreed upon. So you can actually say, we object to party A being in the room, or and you have to give good reasons for this. You can have demonstrative exhibits, which is you not just your documents. You can present it maybe in a PowerPoint. You can bring items. Again, very, very flexible in terms of arbitration. So if you have an IT dispute that you feel is better served, your case is better served by actually demonstrating maybe a certain capability or a certain function than describing it on paper, then you can definitely do that in an arbitration hearing. And transparency, so everything is disclosed to both parties. You can't, for example, the tribunal usually doesn't write to one party ex parte, he has to write to both. Everything is very transparent among the parties and the tribunal. In terms of logistics, I will just go through this very quickly. You have to find a venue. So again, in Singapore, the most popular venue is Maxwell Chambers. You're not required, however, to go to Maxwell Chambers because you can still find other alternative venues. For example, in smaller cases, we've actually held arbitrations in maybe the arbitrator's office if he has a large enough conference room, or we've also volunteered our own conference rooms if the parties agree to it. So there are very different kinds of permutations to this. Usually you prepare hearing bundles, so during the hearing it's very easy to refer to all of your exhibits. You have transcribers, so just like in court where you have stenographers, in arbitration you have transcribers that you hire. Again, usually their charges are per day, and they can provide you with a transcript of the notes either live, which means it's projected on the screen while you're speaking. And this is very, very good if, for example, the witness says something, nobody heard it or you didn't hear it, and you're the one cross-examining. You can just refer back to the notes then and there. You can have it same day, which means at the end of the hearing day, maybe at 5 p.m. or 6 p.m., you can have sometime after that, a few hours, depending on your provider, you can already have a copy of the hearing transcript to review before your next hearing day. And next day is just that. You'll usually get it, the next morning from the day of the hearing. Translators, sometimes it's required when you have foreign, other witnesses who don't speak whatever is the language of the arbitration. The most common language of the arbitration is English, which means all proceedings are conducted in English. But there are many times when your witnesses may be from different countries and they don't speak English, so you can hire a translator. And again, being very transparent with all the parties, inform everybody that you're hiring this translator to help assist with the witness. Recording is something that is not very common. Should you decide to record your arbitration here, you of course have to get the consent of everybody, but it's not always very common. And accommodation. So if you have witnesses, parties, lawyers, arbitrators flying in from different countries just to have the physical hearing, then most of the time there are costs associated with that. And unfortunately, they will be borne by the parties. So it's something to bear in mind when you have arbitrations involving different parties from different countries. So one of the things that I've noticed now because of COVID-19 is that we're starting more and more to have a lot of virtual hearings. So you don't necessarily have to fly to a place in order to conduct your arbitration hearing, in order to have a cross-examination. Instead, it's done virtually, sometimes by Zoom, sometimes by other applications such as Blue Jeans. And if I'm not mistaken, it's something, virtual hearings or online hearings is something that will be discussed in a later webinar in this Digital Transformation Thursday series. So we'll talk about that during that webinar. So next slide is I think the left picture is, I've shown you earlier, a sample hearing room in Maxwell Chambers. On the right is what it looks like. So you have the tribunal at the end, and then somebody's presenting counsels of one party to one side, the other counsels to the other side. Usually everybody brings their laptops or their computers, your documents, your pleadings, and all your evidence. So it's usually like that. It's very different from a court setting, but it's also a lot easier to refer to your documents, and it's private. So nobody else can enter the room except those involved in that particular hearing. So now we go into the award. After the hearing, maybe there are closing submissions, which is more written submissions to the tribunal. And then at some point, you have the tribunal issues the award, essentially deciding the dispute. Now, there are different kinds of awards. You have interim awards, partial awards, final awards. And if you look here, there's a consent award. This is in case of party settlement. What happens is if party A and party B in the middle of the dispute, they decide that, well, okay, you know what, we don't actually need to go through with this entire thing. Instead, we will just settle everything, and they have a settlement agreement. They can inform the tribunal if they want a consent award, and the tribunal will transform that settlement agreement into an award. And the reason parties want to do that is because they want the enforceability of that award. If you recall, as I mentioned, awards are enforceable in almost all countries, in at least 150 countries. So if you have your settlement agreement contained in an award, then you can enforce it if ever anybody breaches that settlement agreement. For post-award remedies, what happens? What do you do if you lose? What do you do if you think that there was some injustice done to you? Or maybe more importantly, what do you do if somebody filed a case against you and you were actually never informed about it? You never knew, and then all of a sudden the tribunal issues an award against you, and you just find out long after that there was an award being enforced already against you. So the general rule is that there's no appeal process in arbitration. That's general. Of course, it still admits of some exceptions. And when you have an award, you also have the option to challenge the award, or you can set aside the award, or you can maybe just settle with the other party. I've seen cases where an award had been issued against the respondent, and maybe for whatever reason they decide, you know what, we will just settle this because maybe they have an ongoing business relationship that they don't want to damage. And I mentioned earlier about setting aside. So what I'll discuss here is how to set aside in Singapore, or at least what are the grounds for it. So under the model law, the UNCITRAL model law, there are certain grounds for setting aside an award. This includes, for example, where a party was under some incapacity, they weren't, generally your contract rules for invalidating a contract applies. If there was no proper notice of the appointment of the arbitrator or the proceedings, or the party was otherwise unable to present his case. So this is what I mentioned earlier, that we've seen arbitrations where the respondent never appeared, but because in arbitration, you just have to prove that you've sent sufficient notice, it's possible for the arbitration to still proceed. So, again, it depends so much on the circumstances of the case, but there are instances where that respondent who was never informed properly can actually file to set aside the award based on he was never made aware of the arbitration proceedings in the first place. Third is when the arbitration or award deals with a dispute outside the scope of the submission, or contains, it's a dispute. The dispute itself is outside the submission to arbitration. So sometimes you see contracts which state all disputes except maybe warranty claims, are subject to arbitration. So if you file an arbitration based on the warranty claim, you can challenge this and say this was outside of the submission, outside the scope of the submission to arbitration. Or there are times when the arbitrator makes a decision on the arbitration beyond what is the actual dispute. So the parties may say, we are only arguing, or we are only disputing on issues 1, 2, and 3. But when the decision or the award comes out, the tribunal actually decides on 1, 2, 3, and he makes another decision on 4. So that's another ground to set aside the award. The next bullet point is composition of the tribunal, or the procedure was not in accordance with the agreement of the parties. So this is why I mentioned earlier, you have to look at the contract. What does it state? If it says that specifically maybe that one of the arbitrators must be an engineer, and you constitute a tribunal where nobody's an engineer, or any other violation of the procedure laid down by the parties, it's a ground to set aside the award. The next one is subject matter of the dispute is not capable of settlement by arbitration. So, for example, in some countries, employment disputes cannot be subject to arbitration. Patent disputes, it really depends on the law of the country under which the arbitration is subject to. And lastly, if the award is in conflict with the public policy of the state, this state refers to Singapore in this particular case. Of course, it could refer to different countries depending on which arbitral law you're looking at. But examples of public policy is for maybe if the arbitrator was actually biased, for example. So that's not a specific ground under all of these, but we have seen cases where the parties try to argue that the arbitrator is biased. Maybe he used to come from the same law firm as one of the parties, and he never disclosed it. The important point is he never disclosed it. And you can say that this affected the arbitration. I was not granted the right to fairly present my case. And sometimes it's an argument that wins, sometimes it doesn't. But these are the kinds of arguments which can fall under public policy. Under the International Arbitration Act of Singapore, they add 2 more grounds. First is that the making of the award was induced by fraud or corruption, so you paid somebody off, or there was any dishonesty in the making of the award, or a breach of the rules of natural justice occurred in connection with the making of the award by which the rights of any party have been prejudiced. So these are the kinds of setting aside grounds in Singapore that you can find. So in this last slides, I will just discuss with you what are the things that you should consider when you're actually faced with an IT dispute. So I'll try to tackle everything that we've discussed in this webinar so far, the points Rebecca raised, the points I've raised earlier in this portion. So you have to know your options and you have to align your objectives with your assessment of the case. So first you look at how strong is your case. Do you actually have the facts to buttress your case? How strong is your counterparty's case? If you feel that your case is not really very strong, do you want to look at mediation maybe? Do you want to look at settlement instead? If you feel that your other party's case is actually very weak, do you want to look at summary or early dismissal procedures? What are the potential claims and counterclaims? So it's something that you have to look into in advance. Do you have sufficient evidence available? So early in this webinar, JJ was saying that proper contract management includes making sure that you document everything and retain all these records in the event of a dispute. And this is completely right. Like, you have to make sure that you know the extent of the evidence available. Because the last thing you want is you're halfway through the arbitration, you're almost at the hearing, you've spent a lot of money, and then you realize your key pieces of evidence are actually not available. So this is also where you decide, do you need an oral hearing? Can you do documents only? Can you do discovery? And usually in arbitration, discovery is actually very popular to, in a sense, extract evidence from the other side that you know exists. Are there any applicable investment treaty or protections? So this is a separate topic, but it was also discussed by Rebecca as to treaty arbitrations. Is there an applicable BIT? Is this even a covered investment? And where are the counterparty's assets? So as I mentioned, even if you get an award and you win, that's not the end of the story. You actually have to enforce it. You actually have to be able to get the money, get whatever it is that you prayed for and you were awarded. So you have to think first, even before you start a case, does the other side actually have the money to pay you? Or are you just sinking money into a long arbitration hearing, and at the end of the day, they'll turn out to be insolvent? Are they, check if they're sufficient? Should you settle? What are the courts like in the places where the counterparty's assets are located? And are there any recognition and enforcement arrangements? Check also whether there are other forms of protection, such as performance bonds that you can just draw upon instead of going into arbitration. And check whether there are any timing issues. Is there a statute of limitations for your claim? Is there a contractual bar to your claim? As I mentioned earlier, some timing issues, they're very important, otherwise your claim can be struck out. So, of course, you have to check what is your overall goal. Is your goal achievable? Is there a continuing business relationship? If party A and party B actually have several ongoing contracts, how feasible is it to file an arbitration against them? Should you then just maybe look at negotiation or mediation instead? Will it ruin the business relationship? What is your appetite to fight the case? Because in arbitration, most of the time, it's a lot faster, more efficient than litigation, but you still have to dedicate a lot of resources into it. You have to dedicate funds, not just to pay your external counsel if you're hiring one. You also have to dedicate manpower within your team to talk with the lawyers, to streamline the evidence, to collect the evidence and gather them for you. So there's a lot of investment here that is being made. So you have to assess personally, how much are you willing to fight the case? Do you have sufficient resources? Can you consider third-party funding, which I mentioned earlier? Is there insurance? And then you check, well, how about the counterparty? Do they have enough money for this as well? And you may want to check, is there a reputational or PR risk? If you're a very big company, there may be certain implications as to, the news getting out that you're actually filing a case against maybe one of your suppliers. And as much as arbitration is confidential, sometimes the parties themselves, and you can't really pinpoint who, will leak it to the media. So if you have those kinds of considerations, then that's something to think about. And are there any urgent circumstances? So in arbitration, you can also have what we call interim measures from the court. And this means that you can get maybe a protection order, an injunction, garnishing of assets, things like these to preserve the assets prior to you actually commencing your case. Or another option is under the SEAC rules, they have a procedure called emergency arbitrator procedures. In other words, an EA procedure. And this is something that was instituted so that parties, usually the claimant, can get rapid relief against the other party without having to wait for the period of appointment of tribunal. So this is very fast. And for example, you sold goods to the other side won't accept your goods. And your goods, for example, are perishable. So you can file an arbitration about that, but in the meantime, your goods are going to perish. So you do need some interim relief, and that's something you can get either from the courts or you can get it from the emergency arbitrator. So that really completes my presentation for today. And if you have any further questions, again, feel free. And I think there's a number of questions in the Q&A box right now. Just feel free to raise them and we will do our best to answer.
All right. Thank you, Janice. Hold on. Okay. Thanks for that, Janice. Can I ask Rebecca to turn on her video, and we'll start answering these questions. Hold on. What am I doing here? Do gallery. All right. Good. Okay. So again, let's answer some of these questions. Actually, there was a question about IT disputes, and they were asking, what are IT disputes? And I have to explain that. So what we really meant was disputes arising from IT contracts. So that's really the kind of disputes that we're talking about. Now, there's a question about fees, and I just wanted to take, I looked it up, and this is the website of the Philippine Dispute Resolution Center, and they do have a schedule of fees. So there are two kinds of fees you need to pay if you were to choose them as your arbitration provider. They're located in the PCCI building in Fort Bonifacio. There's an administrative fee, and it depends on the size of your claim, right? So the higher the size of the claim, the more you have to pay. And then apart from the administrative fees, you have to pay the arbitrators. And the arbitrators, it depends on the amount of the claim. And then if it's complex, it doubles, ×2, there's a factor. And it depends on the number of arbitrators. So if it's number of arbitrators, it becomes ×2. And then there's a computation, and that's the way you would be able to get a sense of what your fees will be. I'm sure that's the same in SIAC in Singapore, Janice. Am I correct?
Sorry, so for SIAC in terms of fees, it's usually computed ad valorem. So for example, there's a schedule of fees on the website as well, and there's a fee calculator. So for example, you have a $10 million dispute, you can input that amount, and then it'll give you the maximum fee that you have to pay your arbitrator and the maximum fee you have to pay for administrative fees.
So that's what we should ask PDRCI to. That's what they should do. They should have a fee calculator here. Okay. There's a question from June De La Cruz directed at Dr. Khan regarding RA 9184. It says that Section 59 provides for an arbitration clause, but the proviso states that parties can agree in writing to resort to other modes of ADR. What do you think those other modes are, and have you seen them in these kinds of disputes?
So first, I want to clarify that the wording of Section 59 makes arbitration mandatory. So there has to be an arbitration clause. The last proviso mentioned by the question refers to that last sentence that says that by mutual agreement, the parties may agree in writing sort to alternative modes of dispute resolution. So that means that the parties can agree that the arbitration clause has to be there. It has to exist in the contract. The wording of the law makes that mandatory. But parties can also agree that they resort to conciliation first or to mediation. So they might agree to non-binding discussion, dispute resolution measures that will bring them to the table and discuss, but there won't be any binding agreements that would result out of that procedure. So they can agree. These alternative modes of dispute resolution, they're provided for, so a list of the available ones are provided in the 2009 ADR rules. So the other forms that can also be resorted to are mediation and conciliation. The key difference here is that it doesn't result in a binding decision like arbitration. But including an arbitration clause still is mandatory. It might not reach that point because parties settle as a result of these other forms of dispute resolution.
Okay, so there's a question here from Christina Exmundo. Actually, I think it's a nice segue for that other. So this isn't the last arbitration, I hope, event that we will have with Jan and Rebecca. So she's saying that ADR should be, as mentioned by by Rebecca earlier, appropriate dispute resolution. Now that we're recovering, we expect more use of technology, hence online dispute resolutions. So, I mean, that's the topic of our next event. If we can get it together, I hope that we can talk about online arbitration, right? This is a trend that you've been seeing, or I suppose it will become inevitable. The earlier example that you mentioned, that you showed on your slides, Jan, was that's an arbitration where the proceedings were viewed live. But now, are you seeing online arbitration where all of the parties and the arbitrators are, or the panel is all in doing it remotely?
Yes, absolutely. A lot of arbitrations right now are being done remotely because even if, usually you have parties from different countries and they can't fly right now, but you don't want the arbitration to be suspended indefinitely, so we do online hearings. And for example, for us in Singapore, even if we are all in Singapore, there is, until recently, there was a rule that you cannot physically gather more than 5 people together. So obviously you cannot have an arbitration hearing with only 5. It's very difficult. So our workaround was to just do online arbitration or hybrid arbitration, where some people are in the room, half of them are connecting via VC.
Okay. Actually, there's a project that I'm working on with our nonprofit is called Digital Freedom Network, one of the co-organizers of this event. And one of the things that we've proposed to the PDRCI is to set up an online dispute resolution system. We are in the early stages of getting that up and running. We've appointed somebody to be in charge, and we're talking to a IT provider to provide that. So it's purely online, complaint online, and resolved online. I have a question here for Rebecca. With respect to the government in arbitration, because under the law, the question is the government cannot be sued without its consent. What about in arbitration? How does the government waive its right to arbitration?
So in government, so we were discussing the arbitration clause earlier, and that essentially is the waiver by government. They are agreeing by contract to waive its right to be brought to arbitration. They are agreeing in a contractual provision, which is mandated by law. Again, Section 59 of RA 9184 mandates inclusion of arbitration clauses in government contracts. So by agreeing to this contractual provision, government is essentially waiving its right to be sued and being brought to arbitration. With respect to investment treaty arbitration, government gives its right, gives consent to be sued in the treaty itself. This is way before any disputes may have arisen. Again, to recall, a treaty is an agreement between countries. So the government essentially, in agreeing to the dispute resolution clause in that investment treaty, without knowing what potential disputes there might be in the future, the government essentially saying that if they breach the treaty provisions regarding the protection of investments in the country, they are essentially allowing foreign investors to sue. So that is why in investment treaty arbitrations, invoking this dispute resolution clause, it's always the government that is the respondent, because the consent by the investor, both parties have to consent to arbitration. When you have your contract-based arbitration, consent is given by both parties in the contract. When you have investment treaty arbitration, the government gives its consent in treaty, in its agreement with that other country. That other country also likewise makes that same commitment. That the consent by the foreign investor is made at the moment it initiates a request for arbitration. So that's consent in contract. So now we've looked at consent in contract-based arbitration and consent in treaty-based arbitration.
Okay, Jan shut off her video for a sec. There's a question here on so I think, so can a lawyer be a better arbitrator? And actually we thank Attorney Ricky Onkiko for fielding the answer here. And this relates to the use of experts in arbitration, and Jan touched on that a bit. So we have in the Philippines construction arbitration, and we have arbitrators who are non-lawyers but are in fact like engineers who are resolving these disputes, and one wonders whether it would be preferable in in an IT type dispute to have an IT professional as an arbitrator? What do you think?
I think for me, it's a very good idea. And I think aside from somebody having that kind of expertise, you also want somebody who is able to understand how arbitration works. And they don't have to be a lawyer, but they should basically understand the field and how maybe there are customary practices in a particular field which are not common in outside of that field. So that would be very useful.
Right, right. So I think the way I understand the use of expert witnesses is this is a way to clarify a certain technical matter and make it understandable to the panelists so that they can then appreciate the dispute and come to a resolution. Okay.
Yeah. So, yeah.
Go ahead.
Also, so generally the duty of the expert when they're an expert witness is actually not to the parties, even if they're the one hiring them. It's actually to the tribunal. They're supposed to clarify things to the tribunal. You know, they're supposed to give independent advice to the tribunal about the case. So they don't advocate for any party, but of course, in reality, they usually agree with the party's submissions. But the general rule is that they're clarifying to the tribunal, and their duty is to the tribunal.
Okay. Wow, ang daming sinagot ni Attorney Okiko. Thank you for filling in the would you guys want to field any of these questions? I know that you're seeing them also, right? The filing fee is the same. I think very good, very very important questions here. Let me see. Why don't you go to a question asked by Attorney Okiko? He said, what are the different kinds of IT disputes? Do they require extensive evidence? How long should IT disputes be ideally resolved? For me, I think, so I'll field that one. I think the different kinds of IT disputes, I mean, the ones that are really the most challenging and will probably end up in arbitration is one which involves some development aspect. You know, they're developing or they're developing software, and then there's a problem because the software didn't work. And sometimes this company's purchase of hardware, and because of the complexity of the project and the software, and sometimes the length of the project, what happens? The reason why it goes to arbitration, because like construction contracts, it becomes these projects there's so much interdependency between the client and the provider that at the reason why they go to arbitration is because between themselves, they're blaming each other for the failure of the project because there's blame to go around. And that's why I think it brings them to this point where they figure, this is not entirely my fault. Why should I be solely liable? And if they fail to somehow come to an agreement, I think it's in those situations where it's more likely to go to arbitration. The other thing that I think in relation to the final slides of Jan, which I thought were very helpful in thinking through whether you should proceed. My understanding of procurement law is that if you're a provider, a supplier to the government, and there's a problem with your contract, then you run the risk of being blacklisted. And when you're blacklisted, you can no longer provide services to other government agencies. And if your business relies on government contracts, that could spell the difference between survival or death of your business. And therefore, I think under those circumstances, in order to prove that you should not be blacklisted, one way would be to initiate an arbitration to prove that it is indeed not your fault. Do you have anything to add about that, either of you?
No, that's fine.
Okay. Let's see. Any tips on how to manage risk in an arrangement where a non-IT party and an IT party agree to collaborate on the development of an IT project that do not have a final set of deliverables? So it depends. I think this question by Andreas might be talking about if you're engaging in a development of a product. So there's There's usually like a business person who understands the process, and then there's an IT person. That, to me, that's more of like a profit share arrangement. And those are common type of disputes. It's very common for the IT guys to come into dispute with, say, the people providing the funding. This is very common in startups. And actually, one of the interesting features of the Facebook corporate structure is that the shares of Mark Zuckerberg for a time had 10 times the voting rights of everybody else's shares. So he knew that his equity can go down to 10%, but he could still outvote everyone else. And the idea there is that the IT guy or the guy who came up with the product will continue to control. Okay. What are the remedies for the party in arbitration? I think this was discussed already. How about enforcement? Rebecca, have you seen challenges locally in enforcing arbitral awards?
Yes, there's definitely challenges to enforcement in arbitral awards. As mentioned earlier, so for example, in the enforcement of a foreign arbitral award, I was involved in the case where the losing party challenged enforcement, and when you're challenging enforcement, you're limited to the grounds set forth in the 1958 New York Convention on Recognition and Enforcement of Arbitral Awards. So these are very limited grounds where the court generally is not allowed to go into the merits decision itself, but is based on what we can describe as essentially, generally but not precisely, we can describe as procedural challenges to the way that the arbitration was conducted or how the arbitration award was reached. So these are very limited grounds provided for in the 1958 New York Convention and also mirrored in the UNCITRAL Model Law on International Commercial Arbitration, which is incorporated in Philippine law and the 2004 ADR Act. So there are challenges, but limited grounds. Judges cannot go into the merits of the award. Also, another way to challenge, so that's a challenge to enforcement. Challenging the arbitral award itself can be achieved through a set aside, and that would depend on where the seat of the arbitration is. The seat where the arbitration seat is, then it can be sought to be set aside in those courts. So, for example, if the seat of the arbitration was in Singapore, set aside proceedings can be brought in Singapore.
All right, thank you very much. So can I just ask both our speakers to have some closing remarks? I'll start with you, Jan.
I think we've tackled a lot of very interesting issues today in this webinar, and in relation particularly to resolving IT disputes, I do think that arbitration is a very, very good option for IT contracts in that it offers a more efficient timeline. It's more flexible to how the parties want it to go. So how much evidence they want presented, what kind of structure they want in presenting their evidence. And again, for me, the best, aside from, of course, enforceability in many countries, one of the best advantages that I see is being able to choose your arbitrator. You're able to choose somebody who is knowledgeable, who understands your industry, who understands your practices, maybe also the parties, their backgrounds, understands the technology that you may be arguing about. So if you're facing if you're considering inking a IT contract, it's very, very good to consider putting in an arbitration clause so as to plan ahead in the event of any dispute. It's a lot easier on your stress level when you know that that's something that's already been taken care of. So I hope that our presentations were very helpful in this regard. And thank you for your time to everybody.
Thank you. Thank you. Can we hear from Attorney Rebecca? Dr. Rebecca?
Hi.
Dr. Khan.
So first, thanks to everyone for listening. I'm really happy that a lot of people came and listened today. the interest expressed in your questions was really made for a really stimulating discussion, and I'm glad that there's so much interest in this topic. I guess if there's one takeaway that I'd like you all to consider is that resort to arbitration begins with the crafting of a very good arbitration clause. So in drafting a contract, whether it's an IT contract or a different kind of contract, always consider including a dispute resolution clause that refers the dispute to arbitration. And remember the key elements of an arbitration clause so that the clause isn't useless. Make sure all the elements are there and make sure it reflects what you want. So thanks everyone for listening, and thanks for the great questions.
Thank you very much. So I'm very grateful to our speakers, Janice Lee and Dr. Rebecca Khan. I'm also grateful, I get the sense that in the arbitration community, in the ADR community, everyone is sort of a warrior, a missionary. You guys are out there, it's a calling, right? You're telling about the good things about arbitration. And I'm very happy that Attorney Kiko of PDRCI joined in and helped out in answering. A lot of people are very passionate about this. I think because we get the sense that this is a very good way to resolve disputes, a very good way to get justice. Now, more than ever, I think with the courts somewhat in lockdown also, maybe arbitration might be a good way to resolve disputes and then move forward. And on that note, we'd like to again thank everyone for joining us today. This is yet I think episode 6 of Digital Transformation Thursdays. Thank you and good afternoon.
Thank you.